Yes, Mr. Ganser. Where do we go from here?
If I may, at the outset, I'd last taken you to this point on anxious scrutiny and MN, and if I may, in terms of the authorities, take you to one other case on this, which is SF at tab 5. My Lord, specifically page 73. Page of the authorities bundle, paragraph 84 introduces the issue that there was a dispute between the parties as to the appropriate level of scrutiny this court should adopt in determining the present dispute. The case for the claimant is that heightened or more rigorous scrutiny should be applied because of the nature of the issues, especially as they will have a decisive impact. Just pausing there. And then over the page, at bottom paragraph 89, reference to HAM and Secretary of State for the Home Department, and then the before Ms. Helen Mountford, because he's sitting as Deputy High Court Judge, and the reference at paragraph 90, if I can draw your attention to that, the context where human rights were involved, anxious scrutiny to the decisions which the defendant reached, and to be satisfied the decisions show by their reasoning, and this is what I was speaking about before, that every factor which might tell in favour of an applicant has been properly taken into account. The greater the likely impact of the decision on the rights of the person affected, the greater the detailed justification and explanation which will be expected. And then finally, before the final part, paragraph 98 on page 76. So pausing at this stage, rigorous scrutiny is required by the courts where fundamental rights are at stake, and this degree of scrutiny is not limited to claims under the Human Rights Act. And then over the page, the last line on 76, these rights have to be considered against the background of the fundamental non-derogable nature of Article 4 of the ECHR. And then setting out, in the case of Ransef, what Articles 2 and 3 and 4 enshrine the basic values of democratic societies making up the Council of Europe. And then finally, this is the final part on this, paragraph 104 of SF. So pulling the threads together, the rationality of a gateway decision that a person is not the victim of trafficking requires a heightened or more rigorous level of scrutiny, both because it relates to fundamental rights and also because it arises in an area in which a court has the requisite knowledge. This means the approach of the courts should be in accordance with the approach of Lord Justice Carnworth, with whom Lord Justice Morvick and Etherton agreed in YH, which again is this the principle that the need for decisions to show by their reasoning every factor which tells in favour of the applicant has been properly taken into account. So I rely on that. And the other authority that I would like to take you to, because I referred to this earlier, the principles that Mr. David Locke, sitting as a Deputy High Court Judge, takes from the guidance, because that also feeds into my submissions on anxious scrutiny. And I would invite this court to endorse those principles. And they are set out in it's tab TBN, tab 10, page 264. And my Lord, I'd addressed you on the point about complex PTSD, and that stands alone as supporting evidence. And the 10 key relevant elements, so paragraph 34, for present purposes, it may also be helpful to draw the following 10 key relevant elements from the guidance about the recommended approach for SCA who are considering statements. Paragraph 34, page 264.
Oh yes, I've got it, yes.
So the first is the primary question.
Yeah. Do you want us to read those 10 points to ourselves?
Yes, I think that would be very helpful. Thank you.
The guidance also at page 253 specifically refers to mitigating circumstances. So it's obvious in our case that the decision maker must have had regard to the guidance.
Yes, my lord. And in
I
fact,
mean, the phrase mitigating circumstances is slightly inaccurate there, because what it's talking about is reasons why there may be inconsistencies in an account.
That's what we, Lord and Justice, Unheld Lay Justice Lang, and I said in MN, isn't it? MN is, if you look at MN, there's a section specifically dealing with this. Where is it? It's at
126,
yeah.
page 184.
No, it's 125.
Yeah, 126.
126. That's where we set out the section. I mean, if we've got this, haven't we, in the guidance
it's
itself?
divider 9.
Yes, and in the guidance there's
It's a 327 in the
exactly
authorities
yes
bundle.
14.5.
14.5,
Yes,
and it's
yeah.
headed mitigating circumstances.
Yes.
Assessing credibility, mitigating circumstances. And what we said was that categorization was not apt. But up to that point, it's perhaps less surprising than it seemed at first blush, to me at any rate, that the phrase mitigation and mitigate was appearing, because it's almost being used as a term, not term of art, that's putting it too grandly, but that may explain why it's being used in what you're calling the boilerplate passages.
Yes.
And of course you will realise that the decision in this case, on the conclusive grounds decision in this case, predated the handing down of the judgment in MN, which was the 21st of December,
Yes.
2020.
Yes.
I think I've got that right. Whereas the
This was November.
November
No,
2020, so it's just so the decision was just before this express criticism of the phrase mitigating circumstances. Well, Julia's shaking her head.
No, this is December 21.
What?
But I think it's MN.
MN was decided in December 20,
No, 20.
and I hope I'm
this,
right.
this,
and
this decision we're concerned with is November 21.
Yeah, so just before MN is handed down.
20, yes. I'm talking about the conclusive grounds decision. That was November 2020.
Oh yes, sorry, yes, that's right.
That
yes.
one would expect, or wouldn't be surprised. I wouldn't put it that way. Wouldn't be surprised if they've stopped using the word mitigating there, in that sense, because it's expressly used in that way. Do you see in the guidance? It doesn't mean mitigating in the guidance.
Yes. Although, I mean, I might be wrong on this. I'll double check it. But interestingly, the same phrases that are used in the decision under challenge in TVN, which is dated April 21. So that postdates MN.
TVN is November 21. So that was the same day on which this decision was made.
No, this is 21. This decision was made 2020. The CG decision in our case.
November 20.
November 20.
MN handed down December 21. The CJ decision in TVM was when? You're telling us April 21.
That was April 21. And the court below, Mrs. Justice Whipple, as she then was, that was 21, November 21.
My point is this, that insofar as I was agreeing with your concern about the word mitigation, or we were discussing that before lunch, I'd overlooked the fact that that's how mitigating circumstances was the phrase used In the guidance to talk when talking about this process, and as we said in MN, it's the wrong phrase. But it may well be that that's how it was being used by decision makers because of what's in the guidance. Do you see?
Yes, I mean it may be.
You're not impressed by my
No, I just think that there's a real. I can see that that's how it may.
I'm getting them off the hook. Well, but you see, it so obviously isn't mitigating, is it? It's a fact. It's a factor to be taken into account. Mitigation is the wrong word.
It's the wrong word, and it indicates the wrong approach, which in turn is exactly what. And I'll come to this. I just make my final points on the anxious scrutiny, and then want to just turn to Mabanga and then the latest direction.
Yeah,
because this is Mabanga.
Yes, of course we go on to talk about this in 126. That is Mabanga.
Yes, exactly this is completely Mabanga, and which is, I think, actually a much stronger criticism about the use of the word the mitigation, because it demonstrates this.
Not just phraseology.
Yes,
it's mindset, which is what we said in one.
Exactly, and that's fine. But my very last points, because then I think we really have gone through the detail of the CG decision, and then I can go to the judgment on that. The only other points to make that I would like to draw your attention to, that Dr. Dunmore's report was relied on in much similar fashion to the other expert reports, and that is at 173. And again, there's no proper engagement with it, other than to say it's acknowledged you're displaying above system. So I'm reading from halfway between the second hole punch and the bottom of the page. However, they're not considered to mitigate the inconsistencies. And then the other 2 points that I wish to make is one, in answer to my Lord's query about, well, actually, isn't your criticism on Dr. Lewison answered by the earlier reference in the decision letter to the appellant's account being broadly in line? And my submission on that is I think that reference about it being broadly in line is at 169, but that is a very general overview consideration of what the trafficking profile is. It doesn't engage in the detail of Dr. Thulison's report. And given Dr. Thulison's expertise and the nature and the reasoning that she sets out, that to find that letter effectively lets this decision maker off the hook, or effectively answers the criticism that in fact anxious scrutiny is not applied, in my submission is not made out. That's the first point. And the second point that I wish to make on the decision letter is that what your lordships will see is that the author of this letter goes from saying, well, there are these inconsistencies and this evidence doesn't mitigate against it, and then repeats that, and then jumps from that, and then I don't think I'll need to take you back to the detail of the decision, straight to saying your account is rejected in its entirety. And my lords will find that repeatedly set out at 174 next to the second hole punch, as noted about your account is rejected in its entirety. And then at the top of 175, again, in its entirety. And again, next to the first hole punch on 175. And our submission is that all of these factors go to underlining the extent to which anxious scrutiny was not applied, and also there is an element of overlap in those submissions on our ground as to the lupus direction. Because exactly what is guarded against, which is just because a part, that doesn't mean all of it should be described, is exactly the error that the decision maker falls into. So that's what I wanted to take you on that. And then on the anxious scrutiny point, that is answered at paragraph 39 of the judgment at page 65 of the bundle. And my submission on that is relatively short. and you have that in the skeleton, which is that the paragraph 39 places significant emphasis on the repeated references to the lies of the appellant, repeated dishonesty, the lies advanced, the lies were of great significance, and that is not considered in the context of the evidence that I've taken you to and the submissions that I've made and the submissions that were before the court below. And now, if I may, I'm conscious of time as well, turn to Mabanga. What I would first like to do is to take you to the relevant parts in MN, and they begin at 175 of MN. And so I rely first, page 175, paragraph 107D. She has failed to treat the expert evidence as an integral part of the findings on credibility, rather than just as an add-on. Sorry, this is MN, page 175, paragraph 107D. So it's just beneath the first hole punch, and in the margin it's the letter D. And then I rely on the end of paragraph 107, quoting Wilson J as he then was, what the fact finder does at his peril is to reach a conclusion by reference only to the appellant's evidence, and then, if it be negative, to ask whether the conclusion should be shifted by the expert evidence, which is the Mabanga error, referred to at 108. I also rely on, over the page, 176, and the just above 109, it is an error of approach to come to a negative assessment of credibility and then ask whether the assessment is displaced by other material. And then specifically, the 182, where the principles are set out as they appear from the authorities, paragraph 121, the first point deals with Mabanga. And after that, my lord has just referred to para 126 about the mitigating circumstances. And I rely specifically on, at the top of page 185, where it's set out, as is made clear in Mabanga, what is required is a single process in which the decision maker assesses the credibility of the core account given by the putative victim.
Sorry, where are you?
Sorry, my lord, the 185.
Just following on the passage we were looking at a few minutes ago.
Exactly. Thank you. 3 lines down, as is made.
Yeah.
A single process in which the decision maker assesses the credibility of the core account given by the putative victim. In doing so, it will be necessary to take into account features which potentially call their credibility into question, such as incoherence, inconsistency, or delay, alongside factors which may explain those features. And then...
Sorry, that's paragraph 185.
126 on
I'm
one.
sorry, it's
page
paragraph
185.
126, page... Sorry if I'm going to...
Right,
page
one-
185.
Thank you.
And then... I'd taken your lordships earlier to the part on anxious scrutiny, which is at page 213 and 214, and the final part that I rely on, which in my submission perfectly sums up what I submit has gone very wrong in the decision letter and in turn has not been addressed, engaged with properly within the judgment, is 215, the very last lines, 2 sentences of paragraph 249. The point made by Mbanga is not that the expert evidence and the issue of credibility must be considered in a particular order. The former must be allowed to feed into the latter, and that did not happen here.
So, yeah, it's 250.
Sorry, I've lost you.
What
Paragraph 249.
No, it's 250.
Oh, sorry, that's my mistake. I said 249. I should have said 250 at the very
250.
bottom of the page.
Yeah. Right.
And, my lords, the cross-references for that Mbanga warning, your lordships will find at paragraph 42 of the skeleton, which cite all the parts where the CG decision repeatedly refers, and you have those, and we've gone through those as I've taken you through how the expert evidence is dealt with.
Yes.
So in my submission, it's absolutely clear that the CG decision erred in that respect, and then in turn, when it came before the court below, the closest reference to the Mbanga point is at paragraph 36 of the judgment. I think it's right to say that Mbanga itself, MN is referred to, but not this point about Mbanga, and that the expert evidence has to feed into the assessment of the lies. Paragraph 36 talks about the structure. So it appears to be engaging with that. The defendant answered on a fair reading that was not the approach. Rather, the conclusion on credibility was reached with the guidance firmly in mind and on the basis of a holistic estimate. I agree, and no more is said on that. And my submission is that the judge erred in not providing any further reasoning as to why she agreed, and also in concluding that insofar as the letter and its repeated reference, it is clear in addressing first the lies and then looking to see whether the mitigation shifts and then saying no, we don't. So unless I can address you any further on the Mbanga point, I say that it's very clearly made out. That takes me then to the Lucas direction, and it's the appellant's case that the decision maker, or the CG decision, was required to direct themselves as to the Lucas direction, and that the failure to do so, the error of law, is demonstrated in two ways, two most obvious ways. The first way in which that's demonstrated is that there is no direction of any of that kind within the letter. And the second way in which it's demonstrated is in the last part that I took you to on the letter, where the writer jumps from saying your account is rejected in its entirety, and there's nothing in between. And so our submission on that is that very, very plainly applying, albeit that it is still a challenge by judicial review, there is an intensity of review that is required, and applying that, that is an error on the part of the CG decision, that it was made out and is not within the judgment.
Well, just pause a moment. Your first proposition is that the decision maker was required as a matter of law to give themselves a Lucas direction. And no such direction was given.
The decision maker is required to apply the Lucas direction insofar as to remind themselves. And
Right,
to
so
apply.
they needn't actually refer to Lucas by name
In the decision.
or repeat the particular jury direction from Lucas, but there must be somewhere a self-direction that because somebody lies about one thing doesn't mean that they lie about everything, and that is a legal requirement. Is that the proposition?
Yes, there's a requirement within the letter that the decision maker has demonstrated that they have given themselves a Lucas direction, and that's why I then go on to say the two ways in which that's not demonstrated is it can be demonstrated by directing themselves to that within the letter, which they haven't done, but actually much more importantly is whether they've done it, and they haven't done it because they jumped straight to the whole account being rejected. And I rely on that because on the basis that the Lucas direction does say it's a direction that decision maker in a judicial or quasi-judicial capacity is required to be aware of.
Right, but I mean, if that is a principle of law, then heightened scrutiny has got nothing to do with it. If it hasn't happened, there's an error of law. That's it.
Well, if yes, I mean these are all. I have a number of errors of law that I rely on, and that's a further one.
Yeah.
Hang on, a number of errors of law. Let me just make sure that I've got them. I understood you had failure to apply anxious scrutiny.
Yes.
And the lies direction.
Yes.
So that's two errors of law.
Those are our two grounds, that's right. And the anxious scrutiny, though, in the way that I've developed it, is that the anxious scrutiny relies on a certain number of aspects to it. But yes, our overriding, our two grounds
Yeah,
of anxious
yeah. Oh, well, I just wanted to make sure.
Yeah. So in terms of the direction, my lords, can I take you to page 17?
Of
The skeleton. Sorry, the skeleton argument. Which sets out, first of all, the direction at paragraph 55, and then taking from Udin,
Yep.
and that's at tab 8.
Yeah, I think you've shown
The
us
warnings.
that. It was quoted in
had
Mr.
that,
Locke's
and then-
decision.
Yes.
Yep.
And then specifically, paragraph 59, that the court below, the judge was specifically referred to Lucas, the Lucas direction, and it was explained, the context which I've taken your lordships to, of those lies, that her ongoing fear, what she'd been subjected to, and her mental health.
Yeah.
And the way that that is engaged with or addressed is at paragraphs 35 to 36, page 65 of the judgment.
Yeah. Well, the judge referred to MA Somalia, which repeats
Yes.
the Lucas direction in the immigration context, so she knew about that.
Yes, and our point is that there's no within the reasoning that is not in any way addressed. That in fact the decision maker, the CG decision maker, did not address themselves, did not apply the Lucas direction. I mean, that's essentially what it comes down to. And so, for that reason,
Yeah.
again,
Well, perhaps we should just call it, it's the Lucas principle, really, because it doesn't really matter a direction.
Yeah.
It's a process that you have to go through. And your point, I think, is that the judge was wrong because she did not examine whether the decision maker had applied the Lucas principle to the fact-finding exercise.
yes, and then and following on from that, I say the decision maker did not.
Yeah. And
As
yes,
well.
you go on to say that when you look at the decision, the Lucas principle was not applied.
Yes, absolutely. Most plainly made out by this jump,
Yeah.
which is exactly what TVN
Yeah.
sets out as well, which I
Yeah,
told you.
which you've gone through
Yeah.
that in some detail.
May I have a moment, please?
Mm.
My lords, those are my submissions, and I'd invite you to allow the appeal.
Can I just ask
Yes.
one question? Sorry.
Yes.
The Mbanga point, which I appreciate was the end of your anxious scrutiny, you criticised the judge below for not referring to it. Was she referred to it?
Yes, yes.
Yeah.
And
It'll be in the skeleton argument, won't it?
Yes.
Below.
Yes, I'm told it's certainly.
I'm sure you're right. It's just
Yes.
if you can give me the reference, I would. Really
Yes.
helpful.
41, page 90, is where you refer to Mbanga.
Yes, but this is. I'm just trying to whether this is. Yes, yeah, you're right.
Thank you.
The judge at 32 refers to the summary of principles in MN, paragraph 121, first of which makes the Mbanga point.
32.
Page 182 in our authorities binding.
No.
Sorry, my lord. Yes, that's right. But when she's dealing with it at 36.
Yeah.
I mean, I've taken that 36 is the closest resembling what must be the Mbanga point. It's not clear from that because it refers to structure. It doesn't do any more than that. In fact, it refers to the guidance and the structure. But it doesn't. She doesn't. Well, she simply says, "I agree. There's a holistic assessment," and we say, in doing so, she erred. In that clearly not being made out, and also in failing to explain why she accepted that there was a holistic assessment. Yeah, but you're right. Yes, she does accept. My lords, unless there's any other point.
No,
Thank you very much.
Thank you very much. Yes, Mr. Keith.
My lords, before we go, I perhaps just want to clarify what you want me to address you on. My skeleton deals with what I thought were the pleaded grounds, which were explicitly drafted as criticisms of Mrs. Justice Whipple's judgment. Although what I understand the case to now be is a criticism of the underlying decision and Mrs. Justice Whipple's alleged failure to properly analyse that on appeal. So if I had misread that, I think my assumption was that the criticism of Mrs. Justice Whipple not giving herself a Lucas direction was perhaps to do with Section 31 of the Supreme Court Act, and that she could have substituted her own decision-making process for that of the decision-making she so chosen to, and should have therefore given herself a Lucas direction.
Well, that's the way I read it too, as I think I made clear, but I don't think that's the way that Ms. Braganza puts it now.
No. In which case, my lord, although my skeleton is in the ballpark, it doesn't address the specifics that my own friend has raised. So I'll try and marry that up.
Yeah.
So, in which case, my lord, we're essentially not so much skirting over the judgment of Mr. Justice Whipple, but analysing whether or not the conclusive grounds decision was wrong on a public law error basis. I think I'm correct in that. I don't want to go off on done more, but I understand that's what we're examining today. And as I think the court, I think it was Lord Justice Baker at the beginning of the day, maybe wrong, analysed those three strands of evidence. There's the account of the appellant, there are supporting documents, and then there is expert evidence. So there are three groups of evidence which the decision maker has to examine. The account is, in my submission, flawed. That was the decision of it's flawed because of the admitted lies. And my learned friend says, well, yes, the lies are accepted, but the decision maker should have sieved out the core credibility issues in this case and found that the appellant had been consistent in the matters that she didn't lie about. That, in my submission, is a very difficult exercise to perform. Because that would also require the decision maker to accept that the only lies that the appellant told were those that she admitted to telling. And so what we're left with, my lords, is an account from the appellant, who I accept on the medical evidence that he damaged to the individual. Is not wholly consistent and has a significant number of admitted lies, which have understandably damaged her credibility in the eyes of the decision maker. And I understand my learned friend's complaint to be that assessment of credibility poisons the rest of the assessment. Therefore, it cannot. Therefore, the decision maker did not weigh all the rest of the evidence in the balance and dismissed this as found it was not a conclusive grounds decision. But in my submission, that's not correct. The conclusive grounds decision does examine all of the evidence. The decision maker is not a lawyer, is not a high court judge, and has done the best that they are able to with the information they are prepared, that they are given. It is a long and detailed decision of the decision maker about analysing the evidence. First of all, the decision maker outlines the evidence they've considered, and then goes on to weigh those factors in the balance. And given that the account of the appellant is fatally flawed, in my submission it was right that the decision maker would then look outside that account given to see whether there was supporting evidence that might assist.
Well, you may be falling into the Mabanga trap that, well, not the Mabanga trap, you may be falling into a trap which Ms. Braganza says the decision maker fell into. You've described the appellant's account as fatally flawed, and that, in a sense, is the question. It is flawed, but is it fatally flawed? Well,
And I suppose I have jumped to the end. So in some respects, I have fallen into that error. But the assessment has to be taken in the round, and you have to assess all three strands together.
Yes.
And the second strand is documents. And I think my learned friend essentially accepts that there is documentary support for some of the appellants.
Some of the backstory. Yes. The journalism,
the journalism,
the photographs of the beauty pageant,
photographs, family, etc. But there isn't any documentary. There's an independent evidence from family, friends, or other documents that supports a claim of trafficking in my submission. So you're then left with an assessment by the experts of the appellant. You have this account which is admitted, at least in part, to be lies, and so you then have to you're then asked to look at the expert evidence and see whether that might support some of the contentions that the appellant makes and lead the decision maker to conclude on the balance of probabilities that the appellant is victim of trafficking. And it is always difficult in my submission for medical professionals to be used to assess credibility of individuals, because Dr. Wootton and the other two experts I don't challenge their conclusions on the diagnosis of post-traumatic stress disorder or the depression or any of the mental health problems that this appellant clearly has, nor could I. But it is a leap from the diagnosis of those different mental health comorbidities to say that because the appellant has PTSD and other associated mental health issues, that she is either A, telling the truth, or her account must be found credible. All that the expert can do.
Do either of them actually say that?
No, but that, in my submission, is what is the expert evidence is being used for.
Yes. I don't think either expert says that either that she's credible or that what she says did happen.
No, they say she's consistent.
Yes.
And I just wanted to come to one, and let me touch on it briefly, is the use of the Istanbul Protocol in this, in the expert evidence. I don't know how familiar your lordships are with the Istanbul Protocol. The Istanbul Protocol is the United Nations protocol dealing with victims of torture.
Torture, yeah.
And how medical professionals should interview and analyse evidence presented by alleged victims of torture. And it's a detailed set of guidance, mainly dealing with physical issues. So the mainstay of it is to examine an individual, look at scars and psychological issues, and say this scarring is consistent, not consistent, highly consistent. And there's a table effectively of how consistent particular injuries are to how the individual gets of torture. And so that's where the phrase consistent, highly consistent, not consistent comes from. In relation to the psychological issues, the Istanbul Protocol is much broader. It doesn't give a graded assessment. It just says, examine the individual, these are the risks, this is how a victim of sexual abuse might present, etc. And is that consistent or not consistent with being a victim of trafficking? But it's not, it's usually the assessment of torture rather than trafficking. And so we therefore have the expert saying that this is consistent. The medical history and diagnosis and prognosis of this appellant is consistent with her being consistent with the account she's given. And what my learned friend says is that, combined with the appellant's account, should be determinative to tip the balance in favour of saying that this appellant is a victim of trafficking. But in my submission, that's a decision for the decision maker to examine the medical evidence in the round with the other supporting evidence and decide whether or not that medical evidence gives sufficient support, gives sufficient explanation for what's happened, and therefore tips, well, I'll come to the burdensome proof in a minute, but passes the balance of probability threshold. And so you've got three credible experts giving expert evidence that's consistent, but that isn't determinative. The determination is taking that evidence plus the account, plus the documentary evidence. Does that get the balance of probabilities? And in my submission, it might get close, but it doesn't tip the balance.
I think the other complaint on the medical evidence is, well, fine, okay, suppose you're right, it's not one that everyone would have to accept, but what you shouldn't do is just give a boilerplate response to it. Well, what's the answer to that?
I think there are two factors involved. Firstly, the boilerplate response is criticised, and it's a double-edged sword. The boilerplate or cut and paste of reasoning is particularly helpful for decision makers, lawyers, judges making decisions in particular categories. And in fact, although not in this guidance, there are a number of examples in the immigration guidance where caseworkers are given specific phrases to use. That's not the case here, but that happens. And my lord, if it were simply a dismissal of Dr. Wotton's evidence by a boilerplate, then I would accept that would be satisfactory. But it's not. It's a brief analysis of what the medical experts say, and then taking that information from the medical experts combined with the other evidence, assessing it all saying that doesn't tip your case into the balance of probabilities.
I appreciate that the decision was taken before our judgment in MN, but do you say it's consistent in this respect with what this court said in MN about how this material should be treated? I'm thinking of paragraph 121
Paragraph 121 of MN.
of MN,
Bring that on the side.
and particularly, well, all of it, and particularly 5. This is on 183 in this authorities bundle. So what they say is, it's with a doctor, it's appropriate for a doctor, it's open to a doctor to express an opinion to the effect that his or her findings are positively supportive of the truthfulness of the account, i.e. an opinion going beyond mere consistency. 3. It may include not just physical findings, but symptoms of mental health. 4. And then the weight to be given to any such expression of opinion will depend on the circumstances of the case. It can never be determinative, and the decision maker will decide in each case to what extent its value has to be discounted for the reasons given by Mr. Justice Ousley in HE. So that's and that deals with medics, and 122 deals with other experts, like Dr. Dawson in this case. So do you say that the so-called boilerplate passages or the overall treatment of the medical reports in this case, the expert reports in this case, satisfied that test, or were consistent with that approach?
Yes, I do, my lord. I wouldn't. I don't submit that the medical evidence in relation to credibility and consistency is completely irrelevant.
Sorry?
It's not that medical evidence in relation to consistency and credibility is completely irrelevant, because it must form part of an assessment from a medical practitioner when analysing when trying to determine whether somebody is telling the truth or not. But that, of course, is not the purpose of a medical report. The purpose of the medical report is a diagnosis of whether the individual is suffering, in this particular case, from PTSD or serious depression. And so, in my submission, it is consistent in that the decision maker looks at the decision of Dr. Wootton and says, we accept you have PTSD and have mental health problems, but Dr. Wootton wraps everything in together and quite rightly says, I can't delineate between what particular instance in your past has caused PTSD. And therefore the decision maker has said, well, you're saying that therefore that's not really any support for the trafficking that you say occurred.
Well, Ms. Braganza points to the paragraph in Dr. Wootton's report where she says that the trafficking was the precipitating cause. Page 90 of the supplementary bundle, question 3, answer D. The appellant's adult experiences of trafficking and sexual exploitation are the events which precipitated symptoms. And then over the page, question 4, answer A. I mean, you're right to say that earlier paragraphs of her report, Dr. Wootton sets out a number of traumatic experiences, section 13, and says that she finds it difficult to separate them out.
So, I think I've got a note to take to question 13 in a minute, but question 3 again asks, the question is Please can you consider the likely cause of any mental health condition with reference to the incident or protocol. Please consider whether the applicant's account of any reasons for symptoms / presentation is clinically plausible. So if the doctor's been asked to give an assessment of plausibility and has gone a bit further than that and say, well, this is the cause, but the only evidence that is the cause is obviously the appellant's evidence. Whereas earlier on, the doctor says, well, there are potentially many causes, and they are probably all codependent on each other. One thing causes PTSD, is a continued series of acts and experiences that have caused this appellant to suffer.
I mean, I suppose you can say that the conclusion or the view expressed in question 3, answer D, is based on the assumption that the trafficking took place, rather than establishing that it did, or even being evidence that it did. It's a conclusion that on the assumption that it took place, this is the precipitating cause.
That is hardly surprising, because
well, the doctor doesn't know.
The doctor doesn't know that, and the purpose of the doctor's report is to assess the damage that has been done to this appellant and the health treatment and what her conditions are. It's not nobody can assess the. All the doctor can say, and she says it at the highest that she can, is that this is consistent with trafficking. And so, does that conclusion, fully exposed to this is consistent with trafficking, plus the appellant's evidence combined, taken in the round, lead to the inevitable conclusion on balance of probabilities that this individual is a victim of trafficking? And not just that, but there's a public law error to that effect. There is in my submission no single piece of evidence or cumulative set of evidence that tips that balance. And if I'm wrong about that the error that Justice Whipple was analysing was whether there was a public law error in that respect. If it was a decision open to the decision maker, then there is no need to allow the appeal.
So really you say that it's wrapped up in the sentence about self-serving nature. Do you?
Yes.
That is sufficient. In this case, that's sufficient to meet the approach, to satisfy the approach subsequently proposed in MN shortly afterwards.
This is in my submission, an extreme case. The lies told, I'm trying to put it carefully, could cause significant issues for the police, and obviously resulted in.
Why does that matter?
Well,
that may be relevant to her getting a prison sentence, but why does it matter now?
It only matters because of the size and complexity of the lies. So, a decision maker faced with somebody who has been convicted of perjury, who has admitted
Perversion of the course of justice. Perversion of the course of justice.
Admitted that significant sections of her evidence are untrue. How is a decision maker, and what Malone friend asked the decision maker to do, say, well, you should just accept that the bits that she says are untrue, and the rest of it is okay for a proper assessment.
Well,
and
the question, as Ms. Braganza says quite rightly, is not simply was the appellant lying, but was she trafficked?
Absolutely.
And she said, yes, she was trafficked. She was trafficked in Turkey, in Albania, in Belgium, and in the UK. and it turned out that she was not trafficked in the UK. And her whole account of being trafficked in the UK was false and made up, and, as you say, elaborate. And that, you may say, well, that was a central question in the whole process. And the fact that she then put her ultimate request for humanitarian protection on a more limited basis doesn't alter the fact that she had told lies about being trafficked, which was the very question at issue.
And it's very difficult to separate out those questions, because although the question is, has she been trafficked on the balance of probabilities, without a main plank of evidence, which is her account, or with an account that is flawed and uncorroborated, the decision maker doesn't have anything else to go on. It's different in an asylum case. In an asylum case, it would only have to be plausible. It would be a lower standard. This is it seems a long way from that, and it is. It's not the criminal standard, it's only the civil standard. But on the balance of probabilities, is significantly higher than the real risk test or the plausibility issues that are espoused by Mr. Justice Ousley in, I've got the name of the judgment, MA, and that assessment. This is a trafficking assessment on the balance of probabilities, and the evidence here, in my submission, doesn't tip that assessment into the balance of probabilities in favour of the appellant.
Yeah.
My lords, is there anything else I can assist you with?
Do you want to say something about Lucas?
Oh, sorry, it's about the Lucas. So, obviously, my skeleton dealt with Justice Whipple's.
Yes, I don't think it's now suggested that she should have given herself a Lucas direction, but she should have examined whether the decision maker had applied what I'll call the Lucas principle. And the Lucas principle, as formulated, as I understand it, is that you should not jump from a finding or an acknowledgement that somebody has lied about one thing to a conclusion that they have lied about everything. That's the principle.
Yes, I think that's
Or, in fact, you shouldn't take a lie on one thing to be proof that you committed an offence on another.
With direct proof.
Let me just find the. Sorry, now I lost the. The decision maker does the balancing exercise, and now unfortunately there are no paragraph numbers.
Fortunately, we've got page numbers.
173.
The balancing exercise is page 174, I think, right at the end. Looking at the available evidence in the round, in your case, it's considered while there's some information that supports your account, looking at all the pieces of information cumulatively, the credibility issues outweigh the evidence in support. As such, it is not considered you have met the required evidentiary standard. That's the balancing exercise.
Yes. And earlier on, there's reference to issues of memory and previous page.
Yeah.
Sorry, memory on where? That's 173. I mean, that's a sort of an explanation of.
Memory is not nothing to do with lies. The first question, the Lucas direction requires you first, at least in principle rather, requires you first to decide whether or not what someone has said is a lie. i.e. deliberate lie. So forgetfulness or memory issues arising through trauma, strictly speaking, come within the Lucas principle. I think the Lucas principle is about deliberate lies.
It's about
told for
lying for different reasons. I think it's about people lie for
First
different reasons.
of all, you assess it has the person told a deliberate lie, and then what? If so, why? And in answering that question, you have to bear in mind, jurists have to bear in mind, and judges, that people lie for lots of reasons. So where's that addressed here by the decision maker?
I'll have to come back in a moment, my lord, with the right paragraph. Unfortunately, as I said, my back highlighting. But the assessment of credibility, I'm going to point out my skeleton, is not the same as a jury. It's an assessment made in the round, taking into account all the factors. It's an assessment made in writing. And the guidance deals with, pretty sure the guidance also deals with issues of
Lies.
Lies and assessing.
Well, that's what the judge says at paragraph 38 of her judgment. She specifically says the decision maker was aware because it set out in the guidance inconsistency or lies. And we can see that the decision maker then used mitigation in an unusual way, which is picked up from the guidance.
I mean, I can't say the mitigation seems to be the incorrect word. But in my submission, that doesn't make any difference to the overall assessment of the credibility of the credibility, not just the credibility.
I mean, I wonder whether there's a slightly different point to be made as well about Lucas. The original Lucas direction is in the context of a criminal trial. And the question is the jury sure that the defendant has done what he's supposed to have done, accused of doing? And he tells a lie. And the jury is told, well, just because he's told a lie about one thing doesn't mean he's told a lie about everything. But the jury doesn't need to be satisfied that he's told the truth. The jury only needs to be satisfied that he may have told the truth. Because if he may have told the truth, they can't be sure. Here, on the other hand, one's got to look at the balance of probabilities.
My lord, I think that was the point I was trying to make here, inelegantly.
Well, we take the Lucas principle into account in other contexts where the standard of proof is the civil standard.
Yes, but
following on from Lord's point, Lucas is about relying on a lie as evidence of an allegation. In this case, the decision maker is doing something different. They're seeking to establish whether the witnesses told the truth about something else. So the lie is being used to undermine the truth of something said by the claimant, as opposed to being used as evidence to support a fact, finding a fact against an individual. I'm clawing my way up to the light here, Mr. Keith, so forgive me if I'm not helping you. As my Lord says, it's a different exercise, isn't it?
It is a different exercise. And my submission, my Lord, it requires a much less sophisticated analysis. In that the
Thank you for.
But in the assessment of the assessment of credibility is what immigration is a large part of what immigration law is about. And how can a decision maker sat at their desk, looking at somebody who has admitted to making serious lies, and is then told, well, everything else is okay. It's definitely the truth, a pretty clear it's just not a realistic prospect that a decision maker can just put out of their head the fact that somebody's told a lie and say, well, but I'm going to believe the rest of them. They have to make an assessment in the round. There's no supporting evidence. There's no supporting documentary evidence. There's no witness evidence. If there was some of that, then of course we'd be in a completely different scenario.
But I think that's what I'm sort of groping towards. Look, the decision maker may say, well, look, the fact that she's lied about one thing doesn't necessarily mean she's lied about everything. She might be telling the truth. She might be.
Yes.
But does that make it more probable than not that she was trafficked? Well, might. More probable? I don't think it does. That might be a perfectly acceptable chain of reasoning.
In my submission, for the appellant to succeed on the evidence that she's got, a decision maker would have to believe her account.
Yeah.
Because that's the evidence.
Yes.
And the decision maker said, I do not believe your account.
It is different from what happens in a criminal trial. For that reason.
And that, in my submission, is the long and the short of the case. Is that the decision maker said, I do not believe your account, having looked at all the evidence. Given that is the key evidence in your case, you do not meet the balance of probabilities.
In carrying out that exercise, whilst it may be that the decision maker doesn't have to go through the Lucas process, does he or she not have to take into account that people do tell lie for different reasons?
Yes, but it's probably the best way to look at guidance. Of course they do, but that's why it's credibility and not the criminal standard of proof. It's not have you told a lie about X and therefore you are hiding a guilty conscience. You're hiding something from the jury or hiding something from the court. It is you have told lies about an aspect of your case. So examining and you've tried to you've tried to explain to us why you did that, because you say that you were still enthralled the traffickers. Fine. So let's look at the rest of your case. And what have we got left? We've only got the appellant's account and the medical evidence that says that's consistent with trafficking.
Well, I think that's the way the judge reasoned it, that the reason for the lie was itself the trafficking, but the very question was, had there been trafficking? So the reason for the lie and the allegation of trafficking were completely intertwined.
And so you're left with not being able to discern the truth.
And then you're into paragraphs 32 and 33 of the Supreme Court judgment in MA, which says in terms that it will depend on the circumstances.
As I say, if this were an asylum appeal, it would be very different.
Do you have a submission about the burden of proof?
The burden of proof must be on the appellant.
Well, what do you say to Mr. Locke?
I perhaps skirted over that paragraph in Mr. Locke's judgment. In my submission, of course, that's the question that's got to be assessed, and the central authority has to make that decision. But it's an adversarial system. All, as we said, the lower standard, the real risk test on human rights removal cases is that the burden is on the appellant.
Is it adversarial?
It is adversarial.
Well,
same thought bubble.
the court system rather than
Well, the court system is, but this is an administrative decision, isn't it? Is that adversarial or inquisitorial, or does it not help to attach labels to that kind of decision?
The claimant said, well, the appellant says she's a victim of trafficking, or in the alternative, somebody refers her as a victim of trafficking, and the state tries to perhaps.
Right. So the assertion which is being tested is she a victim of trafficking?
Yes.
That's the point which is
that's
seeking to, which the decision maker is seeking to establish.
So that's the referral from, in this case, from the police or from the authorities to the central authority who makes an assessment. But and that assessment is all about its probabilities. But then you have to go back to look at what evidence is the central authority going to use to make a decision of whether it's a reasonable ground decision, which they found in favour of the appellant, the second reading. What evidence, but not the conclusive grounds. What are they going to use? Well, they're going to use probably the account of the appellant, potentially evidence seized when they entered the United Kingdom, for instance, if they were stopped at a port, family evidence, witness evidence, medical evidence.
The police evidence when they first encounter and
Police evidence from when they first encountered any contact with the authorities. I mean, for instance, in this case, when you contact the authorities, the police obviously thought there was an issue and they referred.
Right.
But that's the assessment. But if the evidence is, if the only evidence is the appellant's account,
Which it often will be.
And the appellant is incredible, then, and the standard is the balance of probabilities.
In a criminal case, the lies being used by the prosecution as corroborative evidence to support the allegation, which they are seeking to prove.
Yes.
Here, the significance of lies is not to prove the fact which is being established, but actually because it undermines the evidence in support of the fact to be established,
Yes.
which is based, as it has to be, on largely on the account of the applicant.
And any decision-making body is going to take the first position of examining the appellant's account through the lens of admitted lies. Because you've got to analyse whether they're telling the truth and which bits are credible and which bits aren't credible.
But going back, I'm sorry to repeat it, but even in that process, isn't there a need for the decision maker to bear in mind that people lie for different reasons?
Absolutely, but it's a whole. It's the. And that's what the guidance says, and that, in my opinion, what's happened here is that the course victims of trafficking lie for different reasons. They don't want to give the name of the person who has control over them, or don't want to, in asylum cases, don't want to say who is in their country of origin. That is understandable, and that's why the test is lower in asylum, slightly higher here. But it doesn't change the fact that that assessment has to be made in the round of all the evidence that is presented. And in this case, in my submission, there just isn't enough.
Yeah.
My lords, is there anything else on this? No, thank you.
Thank you very much, Mr. Keith. Miss Braganza, any reply?
Yes, my lord, if I may. So the first point that I make in reply is that relying on my certain argument, it's not simply the decision that I rely on as being unlawful, but also in turn the judgment of the lower court and how the judge dealt with that decision. It's not right to say that the focus is purely on the decision. The next point that I do take particular issue with is that Mr. Keith has redirected the focus in my submission on whether the appellant is lying, and that in fact is the wrong focus. The point is she a victim of trafficking? And to say, and it is in my submission, it's of real concern to say that it's assessing her through the lens. I may have misunderstood, but to say through the lens of the lies, that's exactly what should not happen. That is exactly what should not happen. What must happen is that lies must be considered in their context with the reasons provided to them, and also in the context, and this is the Mabanga point, of what the medical evidence sets out. And we have additional evidence here, which is not just the expert saying this is consistent, but this individual has been diagnosed with suffering not only from PTSD, but also complex PTSD. And that in itself is an indicator of multiple trauma. And the expert, it's simply not right to say that all there is in this case is the appellant's account. There's extensive varying evidence, which is always the way. It's a question of drawing how the particular threads are drawn together and how they are assessed. And it's wrong to assess them through the lies, which is essentially what's happened in this case. And I take very, very strong issue with the submission that the Dr. Wotton's report is a self-serving report. She refers, and I have specific references that which I would ask you to consider. I did take you to the medical records, but there are references it's supplementary bundle 77G at page supplementary bundle 8214A at page 89G, and these are all. When I took you to the medical records to say that is further evidence of how she presented, it all feeds in. And is all evidence that has to be considered in its totality. It's suggested that this decision was open to the decision maker to make, and that there was, for that reason, there's no need to allow the appeal. It can't be said that it was that this is the result that necessarily would have followed had the decision maker taken the correct approach and applied anxious scrutiny by any means, because that analysis is simply not carried out. And then it said.
Your point here is, if there was a failure of process, then we can't be sure the decision would have been the same if the proper process had been followed, in which case it must be set aside and sent back for reassessment.
Yes, that's oh yes, there was a point, and this is not direct. I ask for the indulgence of the court on this because it's something I wanted to come back to. It's not directly answering the point, but Mr. Keith says that there isn't support for the backstory. There isn't independent evidence of the family, and my lord had asked about the phone, the sister's phone, and in fact, my lords may have seen that the appellant sought to put in an additional statement, and she was refused permission to do that. And in fact, what happened with that phone is that it was taken by the police and it was destroyed. So that's in partial answer to that. But following on, I would stress that it is inaccurate to describe all the evidence you've seen as being no more than amounting to what the appellant has told everyone. The Mabanga, in my submission, I don't think really the Mabanga error has been addressed. because it's simply not made out by a proper consideration of the letter. And I think the final, which is effectively the same. It seems the thrust of the respondent's argument seems to be, well, it's obviously it's a difficult exercise to carry out. It's on the balance of probability, and ultimately it's all down to her. It's all down to what she says and whether she's lying or not. And that is a complete misunderstanding of what is entailed in deciding whether an individual is trafficking. It disregards the statutory guidance. It disregards what MN sets out and the key principles that are taken from the guidance in TVN. It misregards, there was reference to the Istanbul Protocol. There's a whole section on the Istanbul Protocol, which is all about the psychological assessment, the nature of the examination that needs to take place, the impact of PTSD and complex PTSD. And all of that is applied in turn by Dr. Wootton. And then I think, just to go back, it's absolutely wrong to say the long and short of this case is whether she's to believe. It's whether she's a victim of trafficking with all of that extensive evidence. And that the exercise that's required is simply not undertaken. And in turn, the judge reviewing it, she erred as well in not addressing those errors. And so, if I may have one moment.
Yes, indeed. Well, not in terms, but he did say it was all looked at. But I think he's had his chance.
My lords,
Can I just ask a couple of questions? You referred to the Istanbul principles and the psychological Istanbul Protocol and
yes.
the psychological assessment.
Yes.
Dr. Wootton is a psychiatrist and therefore a doctor. Did you mean psychological or did you mean psychiatric?
Well, the way that it's set out in the Istanbul Protocol, my lord, is psychological evidence of torture as the overall heading, and the relevant paragraphs within the protocol, all dealing with psychological evidence, begin at 235 and go through to 315. And within the protocol, guidance is
Have
set
we got
out.
that?
Sorry?
Have we got it?
I'm sorry, you don't, and I can.
Well, I don't know. Mr. Keith hasn't had a chance to address
Well,
this.
because he addressed you on what the protocol says, it's guidance about it. I don't think
no
he'll.
objection to you having the Istanbul Protocol.
All right. Well, in that case, could you provide it?
Yes, of course. And so what I was referring to, my lord, is that within the protocol it sets out the guidance to be followed in assessing whether a victim has suffered a torture or specifically details the psychological consequences of it and how clinicians are to carry out the evaluation process, and that it requires clinicians to comment on the consistency of the psychological findings and the extent to which these findings correlate with the alleged abuse. And that is what Dr. Wootton has done.
You referred to the evidence from the sister. That was
Yes.
addressed by the judge at paragraph 44. You haven't appealed against the judge's refusal to allow in this evidence. Is that still the position?
Yes, my lord.
Yeah. Okay, thanks. Sorry, it was just you referred to it,
Yes,
and I just want to make sure it wasn't.
Yes, my lord.
Thank you.
There's my submissions.
Thank you, Ms. Braganza. Thank you both very much for your interesting arguments. We will reserve our decision. You will get a draft judgment in due course. That is your opportunity to correct our grammar and spelling, but not our reasoning. The draft judgment will come with a new beefed up embargo, which means what it says. We would hope that you will be able to agree a form of order disposing of the appeal on receipt of the draft judgment. But if you can't agree a form of order, please make short submissions in writing, and we will make the form of order that we consider to be